Let's unpack it then, the proceedings of today at the Constitutional Court. Matodzi Ratshimbilani is the director at TGR Attorneys and joins me now for this conversation. First things first, what stood out for you from the proceedings today? Rather unusual in that you only had one party arguing. We didn't get the benefit of hearing from the other side, putting on the scales of justice counterweights. But nevertheless, I mean, this is the second time this is happening in a matter involving former President Jacob Zuma before the Constitutional Court. What stood out for you?
Indeed, Thulasizwe, I think it's quite regrettable that it was sort of a one-sided show, because we are certainly in a new precedent-setting territory here from our constitutional law point of view. So I think it would have been instructive and helpful to hear different views, but I think nonetheless, the justices and the counsel for the commission had interesting debates. I mean, there were a number of factors. I think the first one, obviously, the commission makes a lot out of the fact that the position of the former president. They use that in what one will call in aggravation of what they think is an appropriate sentence. It probably will be a first of sorts. Often when one is accused, what you do in your other life is hardly relevant to contempt proceedings. But I think, given the nature of this case, it becomes quite relevant. I think also, as you would have picked up, that the justices were wondering why the commission chose the ConCourt as the platform instead of other courts. That's also a technical debate that I think they will have to reckon with, and it would have been helpful if maybe there was a counter view to it.
In fact, Mr. Ratshimbilani,
of course, looking at the...
I'm sorry to jump in there. You raise a point that I was going to raise next with you. That, for me, it stood out that the debate around jurisdiction of the Constitutional Court wasn't as vigorous as, the other matters. For instance, the whole questions around whether or not this issue of him being in contempt of court is urgent, the issue of urgency, issues to do with the costs to be imposed and around the sentencing for contempt of court and the various principles applicable there. I felt that usually the Constitutional Court doesn't want to be the court of first instance on many matters unless it really warrants it. There wasn't much of a debate between the justices and Advocate Ngokaitobi on the question of jurisdiction. Should we take it that the court accepts that it has jurisdiction on this matter?
Look, it points to that, but in particular, you'll recall that this matter is not coming before the ConCourt for the first time. So the order that they gave, that the former president is now in contempt of, was given through a direct access by the commission to the Constitutional Court. So in my view, in a way that has already been decided, the commission is arguing, you made an order, the affected parties in contempt of that, and I think they will be hard pressed to now move out, this aspect of that order and direct it to another court. And I think, I suspect that's why the debate wasn't as robust. But I think it makes for an interesting legal consideration.
And just on the question of how precedent setting this whole matter is, I saw that when Advocate Ngokaitobi was looking for authorities on this particular question, he actually did say that there aren't too many that they could come across, and they ended up citing that case of the Competition Commission around issues of contempt of court and generally not being responsive to what the court orders. That plus the issue of the costs that they want the former president to be slapped with. How precedent setting is this terrain that we are in on this matter?
Look, I think certainly, I don't think so much regarding the cost issue. I mean, the Constitutional Court has in the recent past had to contend with awarding costs of public servants, former public servants, and so on, in the person of the public protector, amongst other people. So I don't think the cost issue is really that resounding, but I think the issue of the imprisonment, I mean, the closest they were referring to there was regarding the compensation commissioner, who I think was given a 3-month suspended sentence, and I think towards the end, I think the justices did inquire, to say, you coming here asking for a 2-year sentence, and I think the counsel said, look, he believes, that case, the compensation commissioner's case, insofar as the sentence itself goes, is not really relevant in this instance here. There are quite unique and compelling circumstances, as I said earlier, given the office of the person involved and the facts of the matter and how it has evolved. So it will be quite interesting. I mean, ordinarily, contempt of court, people are committed for very short periods of time. 2 years by any imagination is quite long, and if it were to get there, it will really stretch, the precedence of sentences on contempt of court.
Yeah, far be it from us to detect a pattern from behavior that has occurred only twice, but it is remarkable that, for the second time, former President Jacob Zuma is not taking part in terms of responding to what is presented by the Zondo Commission before the Constitutional Court. It is worth noting that. What do you make of that strategy of seeming disengagement with the court processes, let alone the Commission of Inquiry itself, but the court processes around the Commission of Inquiry? Is that an advisable strategy? Does it help the former president in any way?
Yeah, look, it's hard to tell, but I think the one thing that it will do, which may be to the advantage of the former president, is that it puts the justices in a very difficult position. They have to be very cautious. If he had an opportunity to make argument, they could have engaged with them, interrogated them and dismissed them or taken them. So really the proverbial ball is in their court. They have to, having had only one party, make a decision that can have quite significant consequences. So I suppose maybe in the former president's view and his team's strategy is that, look, we throw this at them, let them decide, and often when adjudicators are in that position, they tend to be extremely cautious, and maybe it will be towards his favor.
Mm-hmm. All right, thank you for your insights there, Matodzi Ratshimbilani, who is the director at TGR Attorneys, unpacking the proceedings of this morning at the Constitutional Court. Certainly fascinating ground being covered there in as far as the law is concerned, and the case really being heard through the arguments of one party and not hearing what the former president's side is. We do understand that there are people who are applying to be friends of the court, amicus curiae, but we didn't get to hear their arguments as well before the court there. But there is their application. But former President Jacob Zuma not taking part. You will remember, of course, he did say in that statement that he released after the Concord reached that decision, I think it was in January, that let their law take its course, and basically preempting and saying that he believes that the order that the Zondo Commission is seeking for his imprisonment, they will more than likely get. That was his prediction earlier on when he was citing allegations that he's being treated unfairly by the judiciary in this country. So that matter has been, judgment is reserved. We will hear from the Concord later on when they will deliver judgment.